short period of time, just to make sure that he's, kind of keeping up with staying sober. I would ask that the Prime for Life class be ordered. And the reason why I think a short stint of probation would be appropriate is he does have one prior driving related offense from 2005. So, we're talking 21 years ago, but I think it's important that at least he attend the Prime for Life and a short stint of probation just to make sure that he's, keeping his head on straight and moving forward appropriately. I don't think there's any reimbursement costs that were submitted in this particular case, so we would not be asking for any.
All right, thank you, Mr. Fortier. Mr. something that I regret doing. I've learned from my lesson, and I can promise that you won't see me again.
All right. Well, everything that I see before me and have heard about you today indicates that everything you just told me is correct. That this is a mistake, not something that you intended to do, that you've acted appropriately thereafter, that you have a low probability of repeating this behavior. I'm hoping that you understand how quickly things spiral out of control, though, with the use of alcohol. The fact that you only had a relatively small amount, a 16-ounce can of hard lemonade, and the alcohol that you had in your system was relatively low as well. Again, tells me that you weren't out trying to do anything wrong. You just got caught. I'm assuming you're a relatively small person, so that amount of alcohol had a effect on you than it might on somebody else. But you're stuck being you, so you got to make those accommodations, not for what everybody else can drink, but for how it affects you. I think the prosecutor's suggestion that you go to the Prime for Life class will be good because it will give you some more information about how alcohol affects the body with body weights and metabolism, and how it can also affect the community. And I think that will help you continue to make good decisions in the future. So I'm going to follow that requirement, and I'm going to put you on probation again just for a short period of time so that you have a chance to go through that process, and then we'll get you off probation and let you continue with your life that way. So the court's order is that you're on probation for 3 months. There's a $90 oversight fee for that. There's a mandatory $75 crime victim fee and a mandatory $50 justice assessment. There's restitution to GPD for the amount of $170.99 for their investigation costs. Because this is your first offense, I'm going to charge $200 in court costs and $100 in fines, and a local charge of $15. Let me add all that up for you. The total is $700.99. You can pay that over the course of probation. You may perform community service in lieu of some of those fines and costs at the discretion of the probation office. I want you to enroll in and successfully complete the Prime for Life class. I think that will give you some good information to make good decisions in the future. While you're on probation, there's to be no consumption or possession of alcohol, no entrance into a business where alcohol is served by the glass. That means no bars. Even if they happen to serve food, you can't go into the bar. You may go into a restaurant that happens to serve alcohol, but you must stay out of the bar portion. There will be alcohol testing at the discretion of the probation department, and I believe that that's sufficient for your sentence. Do you have any questions for me, ma'am?
No.
All right, good luck to you.
Thank you.
Thank you, Your Honor.
All right, the next matter is the State of Michigan versus Charles Rickman. There are 2 files. The first is 25-43495-SM, set for probation violation. And then we also have file 26-4395-SD, set for sentencing for Mr. Rickman. We have Mr. Rickman with us today.
Yes, sir.
All right, I do see you.
I'm speaking on behalf of Mr. Rickman, Your Honor, on both files.
All right, thank you very much. Looks like on the misdemeanor matter, we're here on a sentencing, so let's do that one first. There was a plea to operating while impaired on June 11th. I do have a Catholic Human Services substance abuse assessment that's been completed. Mr. Fortier, have you received a copy of that?
Yes, Judge.
All right. Mr. Rickman, I'm going to hear from both of the attorneys as to their recommendations, and then I'm going to give you an opportunity to address me directly if there's anything that you want to say before I decide what to do. Mr. Fortier, your comments?
So, Judge, it appears that he does meet the criteria to be diagnosed with alcohol use disorder, moderate/severe. I think a stint on probation, along with the Prime for Life class and usual drug and alcohol conditions, should be ordered. There's $170.99 reimbursement to the Gaylord Police Department that's being requested. I would note this appears to be his first alcohol-related offense, although he does have some significant criminal history. There was a pretty large break between 2010 and 2024. I would note, obviously, that he's on probation out of an assault and battery case from 2025. So I don't know I don't know how he was doing on probation with that. I think this case is what potentially violated his probation. I do think that in light of the fact that he was on probation and then committed this offense, and it's blood
figured we were gonna celebrate a little bit, and it shouldn't have happened.
Well, this has got to be the worst birthday gift ever. All right, I will accept your plea. I do find that you've given me a proper factual basis indicating violations of your probation by drinking and by picking up a new criminal charge. And I do find that you've given me that plea knowingly, intelligently, and voluntarily based on your answers to my questions, so I will accept the plea. Mr. Dick, I assume you want to move directly to sentencing?
Yes, Your Honor.
Mr. Fortier, any additional allocution
paid.
When was that done?
I was done. I made a payment last week of $300, which took 9 days to clear. I made payment on Sunday, which I overpaid, which I paid the rest remaining balance. And last Monday, I put a day in a work camp, and I did Monday this week. I did a work camp. So I have two left, and I also have every day of the every week. I have done my therapist, and I have done a in-person Al-Anon meeting, which I do have.
All right, Ms. Hill, can you confirm what he's telling me?
So for the AA, I'm receiving his logs and they only have 2 per week.
All right, has he made payments and done work camp like he's told me?
I do have the 1 day from last week's report, but I don't have this week's report.
Okay.
And then his fines and costs are now paid in full as of the 26th.
So do I have your attention, Mr. Swift?
Yes, sir.
You going to get everything done in the next 30 days that you need to get done?
Absolutely.
So here's what I propose. We simply adjourn today's hearing for 30 days. I monitor how you're doing, and when you come back, you tell me I've got everything done, Judge, and then I'll dismiss the probation violation against you. How's that sound?
Yes, sir. Do you want me to update the information that I do have from my therapist, which he was supposed to send over last week? And I do have a list of the sign off from Al Anon that I've been attending to every Tuesday. And my Deputy Keller told me that she was reporting me on the work camp. So I only have 2 left on that. And I plan on having those done probably in the next week.
I think the more that you can document, the better. So send in everything that you've got on a regular basis, and I'll see you in 30 days.
Your
Thank
Honor,
Thank you,
just
Your
so
Honor.
you're aware, the self-help meetings are 3 times per week.
You understand that, right, Mr. Swift?
Yes, sir.
Do it, everything that you're supposed to be doing. Don't make me say that you missed this
educational programs. I guess it would be the Crime for Life program. There is a reimbursement request of $271 to the Michigan State Police. So I would ask that the court order that. And again, I would leave up to Your Honor whether or not you want to impose any sort of probation, given the fact that he doesn't live here. I would not have any specific objections if the court did not order probation. I would certainly find it to be appropriate, kind of based on the circumstances, if probation were ordered. But again, just given the fact that he's a Canadian citizen, I don't know how that would work in terms of monitoring him. So I'd leave that up to the court.
Thank you. Ms. George, allocution?
Your Honor, I don't want to belabor any of the points that you received in our memo. This is Mr. Lessig's first offense. He's 25 years old. He's gainfully employed in an industry that he's really passionate about as a hobby as well.
probation, I think that a significant amount of outpatient counseling would be to his benefit. Would ask that the Prime for Life class be ordered, and then any fines and costs. I don't see a reimbursement request up front, but if you can give me one quick second, I can try to see if there is one.
Yeah, why don't I let you do that while I hear from Mr. Dick as to his allocution. Mr. Dick?
Yes, Your Honor. So Mr. Roberts, he has a significant substance abuse history. He does acknowledge that he has some mental issues that he deals with. However, he has he's been lodged since December 14th, released June 29th. He had a significant dry out period, and while I did not have you to speak with him since his release, he does today, Your Honor, appear to be doing quite well. I'm not sure what his intentions are with his life moving forward from this particular point, but I know that he was way back in April when we had our in-person meeting. He was definitely looking for help. He wanted to make sure that he didn't have a relapse. He wanted to keep himself clean and try to get his life back in order. So with that being said, Your Honor, the position where Mr. Roberts is now, I'll let him provide that to the court. But I think that the roughly 7-month period of drying out and having time to get his mind together, get himself together, is something that should be considered and play a large factor into his extensive substance abuse history. That being said, Your Honor, we'd ask that the court also recognize that during that time he was incarcerated, he did not work. So I think the court could minimize any fines, costs in this matter.
Thank you, Mr. Dick. Mr. Roberts, is there anything that you want to tell me? You're still on mute, sir.
Sorry. I just jailed June 29th, and I've been attending outpatient for substance abuse, and I'm currently placed on probation here in Crawford County. Just spent over 40 hours a week, and if I were to go to jail, well, my people are in Florida, and I have 3 dogs here. So if I were to go to jail, would I be able to turn myself in? Would it have to be ASAP, or could it be like a scheduled day?
Mr. Roberts.
I'm not going to send you further, Mr. Roberts. You've already done more than the time that I could give you already, so you don't have to worry about going to jail. The only real question is, do I need to put you on probation? So maybe you could tell me a little bit about what you're on probation for in Crawford County and what your requirements are there.
My requirements, I drop every other week. I have to do outpatient at Grace Center. I'm currently taking Subzov right now. I haven't had no dirty drops since I've been out of jail, and just been maintaining my appointment. My license could be restated this month, but I'm just gonna walk to work. I'm not trying to drive and have the urge to go out and leave town and go out and use. So like I'm not in a rush to get my license back, and just keep up with fines and costs.
How much time are you on probation for in Crawford County?
2 years.
All right. Is there anything else that you want to tell me before I decide what to do?
No, sir.
All right. It appears to me that you're on a significant period of probation already, so I don't know that I need to duplicate any of that. So what I'm going to do is simply do the minimum fines and costs that are necessary in this case. I'll give you credit for the time that you've already done in jail, and that'll be the
from a pretty significant concussion, and I think that has just kind of affected a lot of areas of her life. And I don't think she necessarily intentionally did this. There were some physical issues as well as some other things that were going on with that accident.
Jones, what seems to be the problem with showing up in court?
I didn't realize that I even had needed to, but I mean, between the time that I wasn't there and this time, I had received a letter a month and a half ago just saying that like my license was suspended and I didn't really know why. So I contacted the court and they told me about the warrant and that I was supposed to appear. But as my lawyer had said, I was in a T-bone accident. The vehicle was totaled. I had to go through a lot of therapies and see a lot of different specialists, and just like I still have a lot of issues from like the post concussion syndrome. And I mean, I wasn't trying not to come to court. There was another, I guess, or something like that, that I had taken care of in between now and then. They said that this one I couldn't just take care of, that I had to appear via Zoom. So that's why I'm here today.
All right. Well, I'm going to accept what you tell me
competency eval. I would ask to adjourn this out maybe 4 or 5 weeks to wait and see what that report reveals.
All right, all that does sound like good cause for an adjournment. Let me get a date in September for you, and we can simply go from there. We'll see what the status is at that time.
September 3rd in the morning?
September 3rd at 9 a.m., the first Thursday in September.
It's not a full week, so that should be fine, Your Honor.
are one of the most horrific ones that I have ever seen. I mean, these animals were severely emaciated. I mean, they were dead in a crate, and another individual was seen dragging them out of this house and burying them in a shallow grave in the backyard before they were recovered by animal control. When they made entry into the house, and there was zero food, even for the two dogs that were still alive in this house. There was feces everywhere. There was animal pee everywhere. The officers had to wear respirator masks to even enter this property. I mean, it was awful. Mr. Matisse did send me some medical documents indicating that Miss Burns was around the time of this. The discharge date shows May 6th of 6, and this was referred to our office on I believe it was around May 11th of this year. So we're talking 5 days or so. So I understand she might have been dealing with some medical issues after being the victim of an assault, but 5 days for these animals to look the way that they did seems like a stretch. Seems like to me, this would be a situation that occurred long before she was in the hospital. The biggest thing to me is I don't think that Miss Burns needs to own animals. So that would be one thing. If the court puts her on probation, I would request that it order her not to possess any animals or not to have control over any animals for the duration of her probation. I do think some jail is appropriate, just kind of based on the circumstances here. And this was, again, an awful case. There is a request from the Otsego County Animal Shelter for reimbursement to the costs of the veterinary services that is in a bill amount. It's $677.80. I think the statute allows a combination of up to a year in jail or up to 300 hours of community service. I think this is a situation where the court could be creative, ordering some jail and some community service. Because again, the facts of this one were just absolutely horrific. And so in terms of whether it wants to do jail or if it wants to just do community service or probation or anything like that, I really think it's appropriate to at least exercise the ability to put her in jail for some length of time. And it also appears there was another case that she had, I believe it was prior to this, so I don't think it would affect sentencing in this matter, but she does have a circuit court case. I believe she's set for sentencing on August 5th. I'm not sure what she'd be looking at in terms of that one, but I would ask the court not to consider that case when fashioning a sentence in this one. Again, I think, the $677.80 to the Otsego County Animal Shelter and then a combination of some jail and community service will be appropriate here. And then also order her not to own or possess or control any animals. And I would specifically request any animal, whether it be a goldfish, a dog, a cat, a lizard, anything. I just don't think she needs to have care or control over another life.
Thank you, Mr. Fortier. Mr. Matisse?
Thank you, Your Honor. I hear what the prosecutor is saying. We would like the court to consider community service and probation and try to weigh those heavily against any jail if the court is inclined to order any jail at all. We'd rather, of course, have Ms. Burns not put in jail. However, if the court sees fit, she doesn't have a bad criminal record. And this has been a really rough patch in her life. She was beat up, Judge, and she still has issues with that today. She still goes to see doctors and things. She wasn't entirely that far away from the animals, but she was in bed. She was having trouble doing things, and she needed people to help her for herself. And while it's not an entire perfect defense in this matter, we would like the court to give that to some consideration that she was in a terribly rough spot when this happened. She did believe that she had some people she was relying on to take care of the animals while she was all banged up, and that doesn't excuse her from having the responsibility of those animals entirely, but it is by way of explanation to the court what happened. Ms. Burns has been working on herself, and she also feels terribly about all of this. Even this did happen, Judge, but you know she didn't she did love those animals, and she's upset. She just failed to properly care for them at that time.
Thank you, Mr. Matisse. Ms. Burns, is there anything else that you wish to directly state to me?
Yes, sir. Like Mr. Matisse had said, I don't deny the responsibility that I have over my animals. I was down and out for 2 weeks. The day that I was put in jail on the 11th was the first day that I was physically capable or mentally capable of entering my house. My oldest dog was suffering from cancer, which was confirmed by the animal shelter. They euthanized her. My Pitsky, my boy, they went to what do you call it, neuter him, and accidentally killed him. My young one that was found deceased, I wasn't aware that she was pregnant. She was too young to be having puppies, and these animals have meant my entire life. My oldest dog was 13 years old. I raised all these animals from babies. Mika would have been 2 in June. Pewter would have been 3 in September. And Jade just turned 12 in May. The only surviving of my animals is my bearded dragon. He is with my ex-husband and my son, my oldest son. Anybody that knows me is my animals are a big lifeline for me, and they mean a lot to me. So this is extremely devastating for me. And like I said, I don't overlook the fact that they were my responsibility, but I was not physically able of even caring for myself. Like Gabriel had said, I had to stay with friends of the family to be taken care of, and my son, my 6-year-old, to be taken care of. I did have somebody that said that they would try their best, but they have their own life to go in and take care of my animals. I tried with the condition that I was in. I couldn't do anything at the point in time to my normal capability, and now I'm looking at all of this, and I'm speechless, because that's my family. That was my entire family, and they're not here no more. I don't even get the opportunity to go and see my Pitsky. He was accidentally killed during neutering. I don't even have an opportunity to see my animals anymore. I've always had animals. I've always loved them and cared for them. I mean, at points in time, I've had birds, cats, and dogs at the same point in time. I raise all my animals. I feed all my animals. My house is clean on a regular basis, but I wasn't in my home because I was medically impaired, and I couldn't do anything about that. I was having a hard enough time taking care of myself, let alone comprehending what was going on around me. Even my son. I remember talking to my son twice over those 2 weeks. I was passing out from pain. I was puking up bile. I couldn't walk straight. I feel bad for my animals, sir. And I apologize for that happening. I apologize to myself, too, because I have to live with this every day and know that I never get to see them again. That's all I have to say.
Who came to the house and buried the dead animals in the shallow grave?
A friend of the family, sir. We don't talk very often.
Todd Scott, Your Honor, is the name of that person.
How did that person know to do that, Ms. Burns?
Because I went to the ER the first time, and I hadn't been in the house in a couple days. And he wanted to make sure that everything was okay upon him going into the house. And I had just gotten back from the ER, and he told me, he's like, I don't want to tell you this. He's like, I know you're already going through a lot. He's like, but Mika had puppies, and she passed away during birth. He said they were substantially large puppies, and Mika was, she didn't even come up to my knee. She was a pit bull chihuahua mix. She was very small, and like I said, she was underage, and I had no idea. that she was carrying puppies. I helped Jade birth 2 litters. I took care of all her puppies. My Pitsky was actually my oldest dog's puppy. Todd also has my oldest, my Jade's puppy, Pewter, has his brother across the street. Take good care of my animals, sir. Jade's first litter, she had 7, and I made sure all those animals were allocated to good homes, that they were fed and taken care of. By all means, this was not my intentions for any of my animals, sir.
Who did you, when you went into the hospital, who did you tell to take care of your animals?
I asked for help if they could, but they have their own life, and that was Todd Scott.
The guy that found it?
Yes. It had been a couple days before I finally got to the ER, and he's like, I got to go in here. He's like, I got to make sure the animals are okay. And I gave him the keys, and I told him, I said, do what you have to and what you can do. I said, please. I said, he knew, they watched me. This is the neighbor I stayed with. Todd and Ron took care of me and my son and made sure that we were well taken care of during the time of the initial concussion and TBI. Without them, I and my son wouldn't even been taken care of at the period of time. Everybody was in good intentions, but everybody has their own life too, and I can't expect the responsibilities in my life to be weighed on somebody else if they're incapable of doing all those things at that point in time. Nobody acted in a malicious manner, and my culture and heritage as being a Native American, the proper thing to do was to bury Mika and her puppies, and her grave was desecrated. And that weighs on top of everything else in the situation as well.
Why was the power shut off? No heat available in the house?
There was no power and heat in the house because I have baseboard heating, and even basic use in my house, they were charging me $500 a month for electricity, but I was in my house every day before work to feed and care for the animals, and after work, and to let them out and everything up until the concussion. I was in that house. That house was clean. They were well taken care of. Like I said, I was out for 2 weeks, and all this transpired, and I couldn't do anything about it, sir.
How did the dogs get emaciated?
Jade, I was struggled with her for 6 months. I was feeding her junk, trying to get her to gain weight. She had been developing tumors since my oldest son was 6. He's 12 now, and they just kept getting larger. I knew in myself that she had cancer, but it was appropriate for her to be comfortable at home with her family. She wasn't struggling to get around. She was still eating, but she couldn't gain weight whatsoever. So Jade, yes, she looked at me. Well, she was emaciated, but it was due to the cancer, which the animal control shelter confirmed because I was at a visitation with my children. And my oldest son said he was leaving early because they were euthanizing my dog. I didn't even get to see any of my dogs before they died, sir.
More than the dog who gave birth were emaciated and dead.
No, Mika, like I said, she was a smaller dog. She shouldn't have been having puppies. I think during birth it took toll on her. Sir, I didn't get to witness any of this. I think the birth took toll on her body, and she tried providing for the puppies, and she died shortly after birth.
So why did the other 2 dogs die from emaciation?
They didn't die from emaciation. They euthanized my dog that had cancer because she had cancer, and then my Pittsburgh didn't die from emaciation. I was told they tried neuterizing him and messed up something and accidentally killed my dog. They didn't die from emaciation, and the bearded dragon is still alive. When I was physically capable, my house was in order, my animals were well cared for.
Mr. Fortier, I would like you to bring in, we're going to have a hearing on this. I'd like you to bring in animal control. I'd like to hear some testimony. I'd like to see some pictures. I want to figure out what happened to these animals. What she's telling me is that nothing bad happened and she's not responsible for anything. She's pled to that, but I want to make sure that my sentence is appropriate to the actual activities. So we're going to adjourn today's hearing, and I want to hear some testimony from animal control. I want to see some pictures or videos or whatever other information that you have about the substance of how the dogs were treated and what their condition was. If there was a vet, I'd like to hear some testimony from the vet, or at least a report from the vet. This is sentencing, so I don't know that we need to have testimony, but I'd like to have at least the report from the veterinarian as well. So we're going to have a sentencing hearing. Let me give you a date for that.
May I say one more thing, sir?
In a minute. Hang on.
Thank you.
2 o'clock. August 20th at 2 p.m.
Right.
Anybody have any conflicts with that?
No, Judge.
No, Judge.
Ms. Burns, did you have something else you wanted to say?
Yes, and I temporarily forgot. That's
all right. You can discuss this matter with your attorney. I'll see you again on August the 20th at 2 p.m.
Sir, I remembered. Up until the point, because Mr. Fortier had mentioned that there was no dog food in the house. The day before that I got the concussion, the dogs had just finished the last of their dog food bags, so that's the dog food bag that they found empty. I was going to go to the store the next morning to buy food, and then I ended up in the predicament that I did.
All right. We'll continue this on August the 20th so I can figure out exactly what happened.
Thank you, Your Honor.
Thank you.
State of Michigan versus Carrie Early, file 26-44613-SM, set for sentencing. We have Ms. Early with us. Yes, I do see her. Thank you. Mr. Matisse?
Good morning, Judge. Gabriel Matisse on behalf of Carrie Early, who is here by Zoom for sentencing.
Has there been a substance abuse assessment submitted, Mr. Matisse?
Judge, actually, I believe so, but I've been chasing these around quite a bit. Ms. Early, did you complete a substance abuse assessment on this?
Yes, I did. I completed Bear River, and my therapist should have sent you the assessment that they did while I was there. And
I do not see one, Mr. Matisse.
Judge, I don't actually see one for Ms. Early here. I apologize. Ms. Early, who would that have come from?
Bear River, and we've been communicating the whole time I was there.
Yeah, I know. I just don't actually have the substance abuse assessment from. Would that be Tina Splan?
Yes.
Yeah. I don't actually have her assessment from you.
All right. We're going to adjourn so we can get that. Let me give you a date where we can come back to.
Thank you, Judge.
Any conflicts with August 20th at 9 a.m.?
No, Judge.
All right. So Ms. Early, please work with your attorney to get that substance abuse assessment to him so that he can forward it to the court and to the prosecutor's office well in advance of the August 20th at 9 a.m. date. I'll see everybody then. Thank you.
Thank you, Your Honor.
State of Michigan versus Brody Graveland, file 26-44623-SD. I do see Mr. Graveland is with us. Thank you. Mr. Matisse, is this your matter?
It is, Your Honor. Thank you. Gabriel Matisse on behalf of Brody Graveland.
How do you want to resolve this matter?
Judge, could the prosecutor please put the offer on the record?
I'm sorry, my computer's wigging out.
It was a high BAC case. I believe I just wanted to verify the offer on this one was an OWI.
Brody Graveland.
Okay, hold on 1 second. For some reason, it's not on my list.
I have a plea sheet in the court file from May 26th that says plea to operating while intoxicated, dismiss the count 1 and $170.99 to GPD for restitution. Count 1 is the high BAC charge.
That's accurate, Judge. I was just trying to get the case pulled up. It wasn't on my list here on the computer. So,
all right. So, Mr. Matisse, that's the offer. How does your client wish to proceed?
My client wants to accept this offer, Your Honor, and plead guilty.
All right, Mr. Graveland, you've heard what the lawyers have said. Is that what you want to do?
Yes, Your Honor.
If you do that, you'd be giving up your right to have a trial and all of the procedural protections that would happen at a trial. Do you understand that?
Yes, Your Honor.
Let me go over those in a little bit of detail so that you can make an informed decision. At a trial, you'd have the right to be represented by your attorney. You'd have the right to have a trial by a judge or a jury. You'd have the right to see, hear, and question all the witnesses against you. You'd have the right to present your own witnesses and evidence and get a subpoena from the court to require your witnesses to appear and testify. At a trial, you could testify, or you could choose to remain silent. And if you remain silent, that silence could not be used against you. At a trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal any error. However, if you enter a plea, you'd be limited to asking for permission to appeal, and that might not be granted. Do you understand all of those rights?
Yes, Your Honor.
Do you have any questions about any of those rights?
No, Your Honor.
Understanding all of that, do you still wish to enter your plea today?
Yes, Your Honor.
All right. I'm going to have you raise your hand so I can swear you in. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right, go ahead and put your hand down, sir. Other than this plea agreement in court today, has anybody promised you anything to get you to plead?
No, Your Honor.
Has anybody threatened you in any way to get you to plead?
No, Your Honor.
Are you doing this of your own free choice and free will?
Yes, Your Honor.
The amended charge of operating while intoxicated has a penalty of 93 days and or a $500 fine. Do you understand that?
Yes, Your Honor.
That amended charge would read as follows. It says that on or about April 11th of 2026 in the city of Gaylord, Otsego County, that you did commit the offense of operating while intoxicated in that you did operate a vehicle upon a highway, that is South Court Avenue, while being under the influence of intoxicating liquor or while having a blood alcohol content of 0.08 grams per milliliters of blood. Is that what happened?
Yes, Your Honor.
Can you tell me what vehicle you were operating at that time?
It was my friend's blue pickup. I believe it was a Dodge Ram.
All right. And were you operating that on South Court Avenue in the city of Gaylord?
Yes, Your Honor.
Did you have some alcohol to drink prior to that operation?
Yes, I did, Your Honor.
Can you tell me what and how much?
Some beer and some shots. We were out beforehand.
And did that amount of alcohol cause you to be under the influence of intoxicating liquor?
Yes, Your Honor.
Did you take some breath or blood tests after your contact with the police?
Yes, I took a blood test.
Do you recall what the result was?
0.17.
That accurate, counsel?
That's correct, Your Honor.
All right. Are you contesting that blood test in any way?
No, Your Honor.
All right. Counsel have any additional factual basis questions?
No, Judge.
No, Your Honor.
Either counsel aware of any other promises, threats, or inducements?
No, Your Honor.
No, both counsel believe I've complied with the court rule?
You have.
I do, Judge.
All right. I will accept the plea to operating while intoxicated. I believe Mr. Gravelin's given me a proper factual basis indicating that he was driving a pickup on South Court Avenue in Gaylord after consuming beers and shots, and that caused him to be under the influence and had a blood alcohol content of 0.17, which is above the legal limit. I believe he's given me that plea knowingly, intelligently, and voluntarily based on his answers to my questions, so I will accept that plea. We will need to have a substance abuse assessment done. Mr. Matisse will work with Mr. Gravelin to get that accomplished, and we will rehear this matter for sentencing in approximately 30 days. Let me give you a date for that.
Do September 3rd at 9 a.m.
Anybody have any conflicts with September 3rd at 9 a.m.?
No, Judge.
No, Your Honor.
All right. So, Mr. Gravelin, if you would get working on that as quickly as possible. It takes a few days or sometimes a week or two to get you into that exam, and then it often takes a week or so to get that report back. And so we need to have that as quickly as we can so that gets done in the time limit set for the next court hearing. Do you have any questions for me, Mr. Gravelin?
I did want to say I'm also in the National Guard, so I'm going to have to do their ASAP program regardless of what happens from here on out.
All right. Well, why don't you get some information on that, that your attorney has it so that when sentencing comes, he can articulate and assist you in arguing about that and letting me know what that entails. So I'd be happy to have that information if you could get that for your attorney ahead of time.
Okay.
That's all for today then. Thank you.
Thank you, Your Honor.
All right. Thank you.
State of Michigan versus Scott Cerveny, file 26-44622-SD, set for status conference.
Good morning, Your Honor. Gabriel Matisse on behalf of Scott Cerveny, who is joining us by Zoom.
Yep, I do see Mr. Cerveny is with us. Mr. Matisse, how do you want to resolve this matter?
Mr. Cerveny would like to take the offer. Could the prosecutor please put it on the record for us?
It's for an added count of operating while visibly impaired and to dismiss the operating while intoxicated.
Thank you. My client would like to accept that plea, Judge.
All right, Mr. Cerveny, you've heard what the attorneys have said. Is that what you want to do?
Yes, Your Honor.
If you take advantage of that offer, you'd be giving up your right to trial and all of the procedural protections that happen at a trial. Do you understand that?
Yes, Your Honor.
Detail those protections for you. You could have a trial by a judge or a jury. You could be represented by your attorney at that trial. You could see, hear, and question all the witnesses at that trial. You'd have the right to present your own witnesses and evidence and get a subpoena from the court to require your witnesses to appear. You could testify, or you could choose to remain silent, and that silence could not be used against you. At a trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, you'd have the right to automatically appeal any error at a trial, but if you enter a plea, you're limited to asking for permission to appeal, and it might not be granted. Do you understand all of those rights?
Yes, Your Honor.
Do you have any questions about any of those rights?
No.
Knowing all of that, do you still wish to enter your plea today?
Yes, Your Honor.
It's my understanding that in exchange for your guilty plea to the less serious offense of operating while visibly impaired, that the more serious offense of operating while intoxicated would be dismissed. Is that what you understand?
Yes, sir.
That less serious offense of impaired driving is a misdemeanor offense, has a maximum penalty of 93 days and or a $500 fine. Are you aware of that?
Yes, Your Honor.
All right. I'm going to have to take some testimony from you then. Would you raise your right hand so I can swear you in? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. Go ahead and put your hand down, sir. Other than this plea agreement, has anybody promised you anything to get you to plead today?
No, Your Honor.
Has anybody threatened you in any way to get you to plead?
No, Your Honor.
Are you doing this of your own free choice and free will?
Yes.
All right. The charge against you, the amended charge of operating while visibly impaired, would read as follows. It would say that on or about April the 12th of 2026 in the city of Gaylord and Otsego County, that you did operate a vehicle upon a highway, that is Dickerson Road, while being visibly impaired from the consumption of an alcoholic liquor. Is that what happened?
Yes, Your Honor.
Can you tell me what vehicle you were operating at that time?
2010 GMC Acadia.
And what did you have to drink before operating the Acadia?
Beer.
Did those few beers make you be visibly impaired from the consumption of that alcohol?
Yes, Your Honor.
Did you take any tests after you had contact with the police that showed your breath or blood alcohol level?
I took a blood test and a breathalyzer.
And what were the results of those?
0.13, I believe.
Accurate, counsel?
Your Honor, I believe is
Yes.
breath of 0.138.
All right. Either counsel have any additional factual basis questions?
No, Your Honor.
No, Judge.
Either counsel aware of any other promises, threats, or inducements not stated on the record?
No, Your Honor.
Both counsel believe I've complied with the plea taking court rule?
I do, Judge.
You have.
All right. I will accept the plea. I believe Mr. Cerveny has given me a proper factual basis indicating that he drove his Acadia on Dickerson Road after consuming a few beers, that he was visibly impaired with a 0.13 blood alcohol level, which is above the legal limit. I believe he's given me that plea knowingly, intelligently, and voluntarily based on his answers to my questions, so I will accept that plea. Mr. Cerveny, we're going to have a substance abuse assessment done, and you're going to need to work with Mr. Matisse to get that accomplished. It usually takes a week or so to get in to have that done, and then it takes a week or so afterwards to get the reports back. So we're going to set a sentencing date about 30 days out. Let me give you a date for that.
September 3rd in the morning.
September 3rd at 9 a.m. Anybody have any problems with that?
No, Judge.
All right. Mr. Cerveny, if you would continue to be in close contact with your attorney and get that substance abuse assessment done, we'll adjourn until September 3rd at 9 a.m. We'll see you then. Thank you.
All right. Thank you.
State of Michigan versus Matthew Schaefer, file 26-44474-SD, set for sentencing. We have Mr. Schaefer with us.
Yes, Your Honor.
There he is. All right, I do see Mr. Schaefer. Mr. Matisse.
Good afternoon, Your Honor. Gabriel Matisse on behalf of Matthew Schaefer, who's attending by Zoom.
It certainly does feel like afternoon already.
Oh, gosh. I'm sorry, Judge. Good morning.
That's all right. I have received a copy of a Catholic Human Services substance abuse assessment. It looks like we got it yesterday. I have not yet reviewed it, so I'm going to do that in just a minute. Mr. Fortier, have you received a copy of this?
I have.
All right. Give me just a second here to go through it, then we'll move to sentencing. All right. I've reviewed the substance abuse assessment submitted on behalf of Mr. Schaefer and by Michelle Klein from Catholic Human Services. Recommends that he remain abstinent, complete a Prime for Life program. So, Mr. Schaefer, I'm going to listen to what the attorneys recommend, and then once you've heard what they recommend, I'm going to give you a chance to tell me anything that you want me to hear prior to my making a decision about what to do. Mr. Fortier, your comments?
So, Judge, but for the fact that Mr. Schaefer's only 19 years old, he wouldn't even be here. Essentially, his blood levels were only a 0.036. I would note that the people that were in the car were well over the legal limit. I mean, there was one individual who was a 0.268 and another person who was a 0.114. So my guess is probably that Mr. Schaefer was trying to do the reasonable thing and be the quote unquote designated driver, considering he was very, very low. But the fact remains that he was consuming alcohol while he's underage. And I think based on his youth, I'm hopeful that this is kind of a wake-up call as to what alcohol can do to a person, how it can affect their life. So I do think that the Prime for Life program would be helpful for him. I'm not gonna request the court to put him in jail or to do any work camp or anything like that, because I do think that he was trying to do the reasonable thing and make sure that the other people who were heavily intoxicated weren't the ones driving. So hopefully this is just a lesson learned for him, and he takes the educational courses and really benefits from that knowledge and moves forward with his life, and we don't see him back here with any more issues in the future. Because again, 19 years old, very young, he's got the whole world in front of him. So hopefully this is just a lesson learned.
All right, thank you. Mr. Matisse, allocution.
Thank you, Your Honor. I appreciate Mr. Fortier's reading of how this case played out from my conversations with Mr. Schaefer. That's essentially what happened. And this was a wake-up call for him, Judge. This whole situation was kind of oddly casual for him. He didn't feel drunk. He didn't feel like he was out of control. He was trying to be the person in the car who wasn't going to be the drunk driver, but he's a minor and he still drank alcohol. So if the court would see fit to follow the recommendations in the substance abuse assessment and just treat this towards like Matthew's error in judgment and understanding that he's a young, bright guy. He's got his whole life in front of him. This kind of behavior will never help him. There's no situation on earth, and we've discussed this, where drinking some alcohol and getting behind the wheel will do good things for him. And he just can't touch it while he's a minor. So Matthew understands that, and this isn't going to be a repeat offender, Judge. He understands what's happened, and he doesn't want this for himself.
Thank you, Mr. Matisse. Mr. Schaefer, is there anything that you want to say on your own behalf?
No, Your Honor.
How does it feel to have your buddies get you in trouble?
Horrible, to be honest.
How old do you feel when you're drinking alcohol?
Young. I don't know how old you're supposed to feel. Made me feel like quite a bit like a loser because I kind of got taken away by the cops. But yeah,
I want to say good. So maybe you'll learn not to do dumb things when you're young. That is what young people do. We tend to do young and dumb things. But if you learn a lesson from this, maybe you end up a little older and wiser down the road. So that's what I'm hoping. I agree that you probably were trying to do the right thing, but you did the wrong thing to begin with, which is drinking alcohol. So alcohol and youth don't go together very well. Quite frankly, alcohol and old age don't go together very well either. I see lots of people that are much older than you do much dumber things than you did. But as a young man, you have responsibilities. When the law says you can't drink until age 21, you can't drink until age 21. And then you're stuck with every bad decision that you make if you violate that law. So I am going to take into account that you were trying to do good things. I am going to take into account your youth. We're just going to chalk this up to a learning lesson. And I'll take you at your word that you're not going to come back before me. Because I'm not going to call you young and dumb next time. Okay. I'm just going to say, go to jail. All right. All right. Good enough. I'm going to put you on probation just to kind of monitor and make sure that you understand that this has to become a habit. We're going to do that for 3 months. That'll cost you $90 in probation oversight fees. There's a $75 crime victim fee, a $50 justice assessment. Mr. Fortier, there was not any restitution request, was there?
Not that I had seen, Your Honor.
All right. $200 in court costs, $100 fine.
Sorry, Judge.
Go ahead.
$271 to the Michigan State Police.
All right, thank you. And a $15 local charge. Let me add those costs up. $801. Pay that over the course of probation. Really expensive beer.
Oh.
You may perform community service in lieu of some of those fines and costs at the discretion of the probation department. You must enroll in and successfully complete Prime for Life. That's an educational class about how alcohol affects the body and how it also has an impact on the community. Hopefully that'll help you make good decisions about that in the future. I also want you to attend some self-help meetings. I want you to go to AA. I want you to hear the stories of the people that are there about how alcohol has affected their life. I'm going to have you go 4 weeks, one time a week for 4 weeks, so you get 4 meetings in. And so I want that to be some part of your educational process as well. There is to be no consumption or possession of alcohol or drugs while you're on probation. No entrance into a business where alcohol is served by the glass. That means no bars. You can't go into a bar anyway because you're not 21. You can go into a restaurant that happens to serve alcohol. You simply may not sit in the bar portion. And there will be alcohol testing at the discretion of the probation department. Do you have any questions about the order of the court?
No, Your Honor.
Good luck to you, sir.
Thank you.
Let me give you the number for probation because you will need to call them to get all of this set up. It's area code 989-731.
989-731.
0215.
0215. All right, thank you.
You're welcome. State of Michigan versus Gerald Berry, file 26-44593-SM. Is that for sentencing?
Good morning, Your Honor. Gabriel Matisse on behalf of Gerald Berry, who's joining us by Zoom.
Do you see Mr. Berry is with us? It's like we just got a copy of the substance use assessment yesterday, so I've not had a chance to read that. Let me do that now. All right, I've had a chance to go through the Catholic Human Services Substance Use Assessment Report provided by Michelle Klein after a review on July 7th. Mr. Berry, I'm going to listen to the recommendations from both of the attorneys, and then I'm going to hear from you as to anything you want me to be aware of before I decide what to do. Mr. Fortier, your comments?
So, Judge, I think clearly the evaluation points out that there's a significant mental health issue going on, which seems to be the driver of his substance abuse issues. Looks like there is several prescription medications that he's currently taking to help manage his psychiatric conditions. And clearly, when you introduce other intoxicating substances into that fold, nothing good comes from that. I want to highlight for the court just kind of what's been going on since 2016. So in 2016, convicted of operating impaired, and I'm only going to bring up the substance abuse related offenses because there are some other ones, but then a 2017 conviction for operating while intoxicated. There is a 2019 conviction for delivery or manufacture of cocaine, heroin, or another narcotic. There is a conviction for conspiracy to deliver or manufacture cocaine, heroin, or another narcotic from the same year. A separate conviction for another delivery or manufacture of cocaine, heroin, or another narcotic. A 2019 conviction for prohibited use of chemical agent. A 2021 conviction for prohibited use of a chemical agent. A 2024 conviction for operating while impaired, third offense. And then we're here today. So I think it's pretty clear that there's a pattern of substance abuse related issues that he's facing. I think that the recommendations within the evaluation take that into account. And I do think that the recommendations that are made are appropriate, especially for him to remain abstinent from alcohol and any other intoxicating substances, utilizing his prescription medications as they are prescribed, to continue attending any psychiatric services through community mental health. I think that the ability for him to get some sort of sobriety housing would be good for him, as obviously the evaluation indicates might be some housing issues. So I think those things would be good for him. I would leave the issue of jail up to the court. Gut tells me that some jail would be appropriate to recommend, but I think given some of the concerns outlined within the evaluation, I think for him, treatment, whether that be inpatient or outpatient, seems to be the thing that would really drive this case. So I would ask that the court consider that. And that's it.
Thank you. Mr. Matisse, allocution.
Thank you, Your Honor. Mr. Berry does have mental health issues. He's discussed them with me, and he told me about what happened during this last period. He hears voices, and he takes medication for it. And when his medication isn't sufficing or he runs out, he does things like use inhalants in order to stay level. he's talked to counselors about this. He and I have talked about it. The inhalants do tremendous amounts of organic brain damage, and you just can't come back from that after a certain point. He understands that he needs to stay on top of having his medications there, working with professionals. But I believe that the evaluation really highlights that this is absolutely a mental health driven issue that causes him to want some sort of stability, and he's going the wrong direction for that, and he knows that there won't be any stability that comes from, you know, any fluorohexanes that you can inhale, because those are very dangerous and they damage you. So he does have a history of this. He's quite a bit more stable now. He does have housing issues, and he's got quite a few struggles, but I think he understands that he needs to more proactively stay on top of working with people, getting help, and staying on top of making sure his medications do not run out, so he doesn't have a situation where he's trying to use some dangerous chemical substance in order to quiet down voices and feel level.
Thank you, Mr. Matisse. Mr. Very, is there anything that you want to tell me?
As of right now, I am in the program called the Lion's Den in Roscommon, Michigan. They currently do not let me take any of my meds that I'm supposed to be taking, but I do plan to stay here as long as possible. If it becomes an issue, then I'll be leaving here and going to a rehab that does allow me to take my medication. Other than that, I plan to sign up for the Bear River housing whenever I leave here, and hopefully I can get into there. I just need to save up the money for the deposit that they require.
How long have you been in the Lion's Den?
Since the 13th.
How long do you anticipate staying there?
Just as long as I possibly can until the mental issues, you know, until they say otherwise.
Do they have a certain program that you're in there, or is it kind of open-ended?
Well, in order to get the certificate, you got to stay here to 8 to 10 months. And then there is a staff portion of the program after that that's a 10 months. So I don't decided what I'm going to do yet, but I just wanted to get here before this court date, so that way the recommendation from the assessment said outpatient therapy, and I wanted to do one better and just get into some kind of treatment, and this was free and it was readily available.
Well, I'm familiar with the Lion's Den. I am wholeheartedly in favor of their there. I think they run a great program. I think they do a great service, and you would be well served by taking advantage for as long as possible with that program. I think they will work with you and with your physician if there's any medical treatment that is necessary. I know that they try to do it without that if at all possible, but I would encourage you to use this time with them very carefully and use it to the best of your ability. I think that's a great place for you to be, because otherwise you have a long history of making some really bad decisions. And at some point, a judge like me is going to say, we've tried the treatment program, we've tried everything else. Right now, it's more important to just keep people safe, so we're just going to warehouse you in a jail. I don't want to have to do that. And as you're at the Lion's Den now, I'm not going to do that in this particular case. But you need to know that your history well warrants it. You've used up all of the do-overs and that you're ever going to get. So take advantage of the program that you're in now long term. That's the only way that you're going to get better, is to take your medications and go through the treatment processes so you know how to comply with what you need to do. Does that make sense to you?
Yes, Your Honor. They do not allow my psychotropic drugs that I need for my mental health issues. So I'm going to stay here as long as I possibly can. But if it becomes an issue, I plan to go to Bear River or Sunrise or something, to a place where they do allow me to take those meds.
I hear what you're telling me, and I want you to hear what I'm telling you. If you can stay at Lion's Den, it would help you immensely.
Right.
So don't you have a preconceived idea of how you need to be treated. That's for the doctors and the experts to say. If the experts and doctors say you need to have medicine, great, then have that. But you can't self-diagnose and say, I want psychotropic medications, therefore I'm leaving this kind of treatment and going to get a different kind of treatment. You only do what the doctors tell you to do. And if the Lion's Den can help you without psychotropic medications, then let them help you for as long as humanly possible. You understand what I'm saying to you?
Yes, Your Honor.
All right. So I'm going to put you on probation for a little longer period of time because you've had a real struggle, and I want to make sure that you get the treatment that you're going to need. So I'm going to put you on probation for 9 months. There's a $270 probation oversight fee for that. There's a $75 crime victim fee, $50 justice assessment. Mr. Fortier, was there, I didn't hear any restitution request.
There wasn't OWI, so there wouldn't be any.
All right, I didn't know if there's anything else, but all right, thank you. I'm going to minimize the fines and costs as much as I can. There's $200 court costs, $100 fine, a local charge of $15. Let me add up those requirements. Total of $710. You pay that over the course of probation. You may perform community service work in lieu of some of the fines and costs at the discretion of the probation department. I want you to enroll in and successfully complete the treatment program that you're in. So that would be the Lion's Den substance abuse treatment. You must also comply with all community mental health or other mental health treatment. That would include meds, counseling, and housing. And you must sign a release to probation so that they can monitor how you're doing on all of those programs. While you're on probation, there's to be no consumption or possession of alcohol or drugs. No entrance to do business where alcohol is served by the glass. That means no bars. Drug and alcohol testing at the discretion of the probation department. Because you're in treatment, I'm not going to impose any work camp or jail program. You must follow all substance abuse and community mental health treatment requirements. Do you have any questions, Mr. Berry?
So the counseling that they offer here, is that enough, or do I have to get a hold of CMH?
As long as you're doing what they require you to do. Once you're done with the Lion's Den treatment program and you're out on your own, then you need to follow whatever community mental health or your other mental health treatment providers say for you to do, whether that's just medication or whether that's medication and counseling or whether that's inpatient that you need to go on a every once in a while basis. Whatever they say to do is what you need to do. Okay?
Yeah.
All right. Good luck to you, sir.
Thank you.
All right.
You're good. It just got.
So on that one case, there's a motion to revoke bond hearing.
Next matter is the state of Michigan versus Matthew Wixon, file 26-44627-SD. Mr. Matisse.
Good morning, Your Honor. Gabriel Matisse on behalf of Matthew Wixon, who is participating by Zoom, and he's still muted. So, Matthew, there you go.
Oh, I was going to say, I think I just said it. Sorry.
It's all right. I do see Mr. Wixon is present. I have before me a request from the prosecutor's office to revoke bond. Mr. Matisse, have you received a copy of that motion?
Judge, I'm not aware of this motion at this time. I'm sorry. No, I'm not.
Looks like it was dated 7/8, so it should have been gone out. We received it July 8th as well. Mr. Fortier, do you have proof of service on Mr. Matisse or not?
The notice of hearing was sent by Miss Byrne on 7/8. Proof of service.
Yeah, I see a copy of that as well.
Yep, 7/8.
Well, let me read it to you, Mr. Matisse, so that you can consult with your client about that. It says, on or about June 8th, the defendant was arrested for operating with a high BAC. Same date, he was arraigned and was granted conditional release. Bond conditions included daily PBTs. On or about June 30th, he appeared at the East Jordan Police Department, and his PBT results were a .066 and a .068. He denied consuming alcohol. Paragraph 4 says that he's in a violation of his bond conditions and his bond should be revoked. And that asks the court to do that. There's a copy of a report from, looks like East Jordan Police Department by reporting officer B. Cease, S-E-E-S-E, that says that at 7:30 a.m. Matthew Wixon took PBT at the East Jordan Police Department. Results were .066. Matthew stated he did not have any alcohol to drink. Stated he brushed his teeth and used Crest mouthwash before he came to the police department. Eyes were bloodshot. Did not smell any alcohol coming from him. at 7:45, so 15 minutes later, took another PBT and the results were a .068. Again, denied consuming any alcohol. Advised he was on bond from Otsego County. So,
I appreciate that, Judge.
I
I did find that, Your Honor. For today's purposes, Judge, Mr. Wixon was going to plead on the underlying case. I don't know if this new bond violation would interfere with that, or if that's going to change Mr. Fortier's offer.
It won't. If he's going to plead to the underlying offense, then we can dismiss the bond violation.
I appreciate that, Mr. Fortier. Mr. Wixon, is that what you'd like to do today? We talked about the offer. You would plead to the OWI first offense, and if you're willing to plead guilty to the bond violation, we can move forward with your plea today.
Absolutely.
So as I understood, Mr. Fortier, it was to dismiss the bond violation for a plea to OWI. Is that correct, Mr. Fortier?
Yes.
All right. So, Mr. Wixon, do you understand that the offer is to plead to operating while intoxicated, dismiss the bond violation, and I believe also dismiss the more serious operating with a high blood alcohol charge, which is what you're currently charged with? Is that your understanding?
Yes, sir.
Operating while intoxicated, the offer that's been made to you is a misdemeanor offense with a maximum penalty of 93 days and or a $500 fine. The current charge against you, operating with a high BAC, is a misdemeanor offense, but it has a much higher maximum possible penalty. Do you understand all of that?
Yes, sir.
If you were to take advantage of this offer today, you would not have a trial and you'd be giving up all of the procedures that offer protection at a trial. Do you understand that?
Yes, Your Honor.
Let me just finish making a note here. All right. If you wanted to take advantage of that offer, as I said, you'd be giving up your right to have a trial. And these are the rights that you would have at a trial that you would be giving up. You'd have the right to have your attorney represent you at that trial. You could have a trial in front of a judge or a jury. You'd have the right to see, hear, and question all the witnesses against you. You'd have the right to present your own witnesses and evidence and get a subpoena from the court to require your witnesses to appear and testify. At a trial, you could testify or you could choose to remain silent, and that silence could not be used against you. At a trial, you'd be presumed innocent till proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal any error at that trial, but if you entered a plea today, you'd be limited to asking for permission to appeal, and that might not be granted. Do you understand all of those rights?
Yes, Your Honor.
Do you have any questions about any of those rights?
No, sir.
Understanding all of those rights, do you still wish to enter your plea today?
Yes, sir.
All right, I need to take some testimony from you, so would you raise your hand so I can swear you in? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, go ahead and put your hand down, sir. Other than this plea agreement, has anybody promised you anything to get you to plead today?
No, sir.
Has anybody threatened you in any way to get you to plead today?
No, sir.
Are you doing this of your own free choice and free will?
Yes, sir.
All right. The amended charge of operating while intoxicated reads as follows. It says that on or about June the 7th of 2026 in the city of Gaylord in Otsego County that you did operate a vehicle upon a highway, that is East Huron Street, while being under the influence of an intoxicating liquor or while having a blood alcohol content of 0.08 grams per milliliter of blood. Is that what happened?
Yes, sir.
What vehicle were you driving during this offense?
It was a black 2020 Hyundai Elantra.
And what did you have to drink before driving that Hyundai?
Some rum on the river.
How much?
Probably about a pint.
And did that amount of alcohol cause you to be under the influence of an alcoholic liquor?
Yes, sir.
Did you take any breath or blood tests after your contact with the police?
Yeah, we went right to the hospital and they drew blood.
Do you recall what the result of that was?
0.34.
That's
That
correct.
sound accurate, counsel?
That is
All
right, Your Honor.
Any other additional factual basis questions by either counsel?
No, Your Honor.
Either counsel have any additional other promises, threats, or inducements not previously stated on the record?
No, Your Honor.
Both counsel believe I've complied with the court rule?
I do, Judge.
You have.
All right. I will accept the plea in this case. I do believe it was given knowingly, intelligently, and voluntarily based on the statements of the Mr. Wixon based on my questioning. I believe he's given me a proper factual basis in that he told me that he drove a 2020 Hyundai Elantra after drinking a pint of rum and that he was under the influence and that he had a 0.34 blood alcohol content. Mr. Batiste, we're going to need a substance abuse assessment done in this matter.
Understood, Judge.
So Mr. Wixon, your attorney is going to assist you in getting a substance abuse assessment. We need to adjourn to get that before the sentencing, so we'll do that as quickly as possible. Let me get you a date for that.
Do September 3rd morning.
September 3rd at 9 a.m. Any conflicts with that?
No, Your Honor.
No, sir.
All right. Mr. Wixon, I would simply state that your blood alcohol in this case was extremely high, and the PBT results that I looked at that were dismissed against you were very disconcerting to me. What I'm trying to tell you is if there's any more of that, it will significantly impact your jail assessment that I do for sentencing. Do you understand what I'm saying to you?
Yes, sir.
All right. Get your assessment done. I'll see you on September the 3rd at 9 a.m.
Thank you, Your Honor.
State of Michigan versus Renard Wilcox, file 18-35584-SM. Is that you, Mr. Wilcox, from the jail?
Yes, sir.
All right. Looks like we're here on a status conference. Do you have counsel, Mr. Wilcox?
Judge, I was recently assigned to Mr. Wilcox, and I've been calling numbers and looking for him. I had no idea Mr. Wilcox was in jail, so I apologize to Mr. Wilcox. I've had a couple phone numbers. I actually did not see you on the Otsego County Jail roster, so I apologize, Mr. Wilcox.
Well, why don't we do this, Mr. Matisse? You now know where he's at. If you could try to get a hold of him over the lunch hour and see if you could speak to him about that. We'll recall the case this afternoon and see if you are able to resolve it. If you're not, that's fine too. But if we could move forward, I'd appreciate that. So I'll simply adjourn today right now. We'll recall it this afternoon. I'll give you a chance to speak to him at the jail so you can discuss how to resolve this matter.
Okay. Thank you, Your Honor. I appreciate it.
Thank you very much. Sorry to the jail staff, but we'll bring him back this afternoon if you don't mind.
Yes, Your Honor, that's fine.
Thank you.
Thank you. Sir, do you need anybody else?
Not this morning. We'll talk to you this afternoon.
Yes, sir.
Thank you. State of Michigan versus Zarian Aldrich, file 25-44219-SM, set for sentencing.
I'm right here.
All right. I do see Mr. Aldrich is with us. This is a review of looks like a delay of sentence on a retail fraud third matter. Mr. Fortier, does it appear that Mr. Aldrich completed all of his requirements successfully?
I don't have any record that restitution was paid.
Mr. Aldrich, I believe there was $151 of restitution to be made to Walmart.
I know I made that. I have the.
All right. My court staff is indicating that their records indicate that you did make that. Did you also attend the economic crime class? Mr. Aldrich, are you able to hear me?
I didn't get any information and I tried to, but
So you weren't able to attend the economic crime class? Can you not hear me? I think we're having some technical difficulties with Mr. Aldrich.
I showed it on my thing that I was only supposed to pay the thing, and I was.
Mr. Aldrich, your connection is breaking up so
hold on.
badly. I can't understand anything that you're saying at the moment.
Order court delay. Hold on, give me a second.
All right. I can see you a little bit better now. Are you able to hear me?
Is this better?
I can hear you now, so it does seem to be a little bit better. Am I understanding that you did not complete the economic crime class?
I did not. I was looking on the thing and it said I only needed to pay the amount of money, and if I still need to take the class, I can take it now and like as soon as possible if you need to.
All right, let's do that. I'm going to give you a telephone number to call for the probation department to set up that economic crime class. Yep, go ahead. As soon as you're done with that class, I'll take you off probation.
Okay, thank you so much.
Or off the delay of sentence, okay?
Yeah. Okay. I'm ready for the number.
It's 989 area code 731-0215. That's the probation department. And you simply need to get information about the economic crime class.
Okay.
All right, that's all for today then, sir.
Okay, thank you so much.
State of Michigan versus Christopher Saltzman, file 26-44543-SM.
Yes, sir.
You see Mr. Saltzman. Thank you very much, sir. Mr. Saltzman, I believe that this is, to the paperwork, please. Looks like you failed to appear on June the 17th. So we did a bench warrant for your arrest because you'd also failed to appear back on June 1st and May 18th. What seems to be the problem with showing up in court?
Yes, sir. So I was arrested in Michigan, and I'm from New York. So the first letter I received in the mail, I received it late, and then I had court. I want to say it was in June when I had court for the first time, and then I was supposed to meet with the prosecutor. I received the letter in the mail on July 10th, and it was supposed to be, I think, June 10th, or the beginning of June. So I think there's just been some problems with me getting the letters in the mail. They have my email now, so this time the email worked a lot better. I got it, and I just the last thing on is a bench warrant, sir.
The last thing I want to do is do a bench warrant for you, but I'm glad you're here now. So I think what I'm going to do is withdraw the bench warrant, and we'll just proceed on the underlying case because now we're able to get a hold of you and you have shown up. So we'll do it that way, and we won't require you to do anything more on the bench warrant. The charge against you, let me go through that process with you. It's called an arraignment. So I'm going to tell you what you're charged with, tell you what your rights are, and then we'll kind of decide where we go from here. The charge against you reads as follows. It says that on March 25th of 2026 in the city of Gaylord, Nassau County, that you did commit the offense of using emergency 911 service for an unauthorized purpose. It reads that you did knowingly use or attempt to use an emergency 911 service for a purpose other than to call for an emergency response from a public safety answering point. And that's contrary to the Michigan compiled laws. That's a misdemeanor offense. It has a maximum penalty of 180 days in jail and or a $5,000 fine. As to that charge, you have the right to plead guilty, not guilty, or no contest. You have the right to be represented by an attorney. If you cannot afford an attorney, one would be appointed for you. And you have the right to have a trial by a judge or by a jury. If you wanted to have a trial, you'd have the right to see, hear, and question all the witnesses at that trial. You'd have the right to present your own witnesses and evidence and get a subpoena from the court to require your witnesses to appear and testify. You'd also have the right to testify yourself or to remain silent and not have that silence used against you. In addition, you'd have the right to be presumed innocent until proven guilty beyond a reasonable doubt and to have that burden of proof remain with the prosecutor at all times. Finally, at the trial, you'd have the right to automatically appeal any error at that trial. Do you understand all the rights that I've just given you?
Yes, sir.
Do you wish to have an attorney? Do you wish to get your own attorney? Do you wish to have a court-appointed attorney, or do you wish to proceed on your own today?
So when I was in court before, they told me I could speak with the prosecutor about making a deal, possibly.
Yep, we can set that up if you want to proceed on your own. And then if you wish to have an attorney in the future, you can just tell me that, and we'll make that arrangement. Is that what you do today?
Oh, yes, sir.
All right. Mr. Fortier, I know we're very busy today. Do you want to have him call in on a Wednesday when the normal pretrial dates would be?
Yes, please.
All right.
He can do it this upcoming Wednesday.
Yep, this upcoming Wednesday is going to be September the 2nd. Typically, is that at 9 o'clock in the morning, Mr. Fortier?
Yeah, what we've been doing, because we've had so many of them, is everyone just calls in at 9. We take messages, and then I just start calling people back in order of when they come in.
All right. And what number should he call for that?
989-731-7430.
All right. So on September the 2nd, this coming Wednesday, sir, you're going to call the prosecutor's office.
Be August 5th.
I'm sorry, August the 5th. I apologize for that. I looked at the wrong date. August 5th, and then you will then contact the prosecutor's office. They'll call you back. And then we're going to set another status conference later in August for you to come back into court and tell me how you want to resolve this matter, whether you want to have an attorney or not, or what you would like to do. Let me get that date for you as well.
Do August 20th in the morning.
Do you have any conflicts with coming back to court via Zoom on August the 20th at 9 a.m.?
No, sir. As long as I know the date, I work out of town, but as long as I have the date and I can give my employer a little bit of a notice, it should be fine.
Yeah, that's why I'm telling it to you right now. So we're going to come back into court on August the 20th at 9 a.m. via Zoom, just like you are today, and we'll see you then, sir. All right?
Okay, thank you very much, sir.
All right, thank you. That's all for today.
Okay.
State of Michigan versus Amanda Smith, file 26-44409-SM, set for sentencing. Do we have Ms. Smith with us?
Your Honor, I do not see that name.
All right, this is a review of a delay of sentence that was done back in April. It looks like you still have not done the economic crimes class as of July 20th. Mr. Fortier, can you confirm whether or not restitution has been made?
It doesn't look like it. I'm not even, well, actually, it looks like she pled on Mark.
Right. This is simply a delay review.
Yeah, I don't have any information on anything that she's done or hasn't done.
All right, I'm going to do an order to show cause then for failure to appear today, and we'll find out what her issue is with not doing what she's supposed to be doing. All right, and the last case this morning anyway, Michigan versus Katie McQueen, file 25-43710-SD, which was originally set for probation violation. Ms. Hill, do you have any contact from Ms. McQueen?
I have not, and I would request a show cause, please.
All right, for the failure to appear, we'll do a show cause.
Judge, I would note, I did see her on the Zoom earlier this morning.
Well, I called the case at the beginning of the session. Nobody appeared for that. And so I waited until afterwards. So if you know how to get a hold of her, or if you can get some information about her, we can use that at the show cause. I'm not going to issue a bench warrant, but I will do the show cause. But thank you for the information that she.
Yeah, I know. I just wanted to just say I did see her. I didn't know what she was here for because she wasn't on my list. So,
Your Honor, before court ends, Michael Gianosa, we called him this morning and I requested a show cause. His hearing's actually at 1:30. Can we remove that show cause?
Yes, we'll just recall it at the 1:30 time period. Thank you for bringing that to my attention.
Yes.
All right. Thank you all very much for your assistance this morning. We're going to take a. I'm sorry, Mr. Lounsbury, you're on mute right now. What can I help you with, sir?
I have a status conference at 9:30 this morning. I've been here since.
Let me check on that for you.
Thank you.
The only ongoing case I see for him, he's on probation, but there's nothing set for this morning.
Do you have your notice with you there, Mr. Lounsbury?
Yes, I do.
Brent, are you still in that case?
I don't know.
I got 3 of them actually for a status conference at 7:30, 2026, 9:30 a.m. I have another status conference set for the same day and time, and also the third piece of paper, which says the same thing.
Okay,
I do have all my fines paid off.
All right. In the upper right-hand column, what case number does it give?
Case number 25-43627-ST-3.
All right, we're going to look that up and see what the status shows us here.
Okay.
Let's look. He may have had a status conference for his unpaid fines and costs. That one is paid off.
All right, that one's been taken care of because you paid your fines and costs off, so that one's done. Do you have a different number in any of the other cases?
Yes.
Why don't you read me that number?
Case number 24-43096-ST-3.
All right, we'll look that one up.
Looks like the same. Got a status conference, but
that's been paid, so that one's taken care of. You have another one?
I truly do.
What's the number for that one?
25-43700-ST-3.
All right, we'll look that one up.
Same situation. He was scheduled, but he paid his fines and costs.
You've paid your fines and costs, so you do not need to be here today, Mr. Lounsbury. Thank you very much for clearing all that up for us.
Hey, thank you so much.
Have a good day.
You too.
All right, with that, the court will be in recess till the afternoon.